But first tonight, the breaking news involving former President Trump. Here in New York City, a judge ruling that the former president committed widespread fraud. The judge determining Trump lied for years about his net worth by inflating the value of his real estate portfolio. The judge finding the evidence so overwhelming, they don't need to go to trial. The former president accused, along with his two eldest sons, Don Jr. and Eric. Among the properties the judge found they inflated, his Fifth Avenue apartment in Trump Tower by as much as $200 million, and inflating the value of Mar-a-Lago in Florida by nearly $600 million. In bringing the suit, New York Attorney General Letitia James had accused Trump, his sons, and his business of overstating their net worth by as much as $2.2 billion, duping banks, insurance companies, and business partners. Tonight, the judge deciding the evidence is clear.
Hello, and welcome, guys. This is happening right now. A federal judge has not just issued a ruling against Donald Trump's business empire. He has placed it under ongoing judicial supervision. We are talking about a court-appointed monitor operating inside the Trump Organization, restrictions on accessing loans from New York-regulated financial institutions, a confirmed fraud finding upheld by an appellate court, and a growing judgment that is accruing interest daily.
Let me just read a little bit from the summary from Judge Engoron's decision, because I think it's worth just reading out loud. In order to borrow more and at lower rates, defendants submitted blatantly false financial data to the accountants, resulting in fraudulent financial statements. When confronted at trial with the statements, defendants' fact and expert witnesses simply denied reality. And defendants failed to accept responsibility or to impose internal controls to prevent future recurrences. As detailed herein, this court now finds defendants liable, continues the appointment of an independent monitor, orders the installation of an independent director of compliance, and limits defendants' right to conduct business in New York for a few years.
The headline you are seeing, Federal Judge Strikes Hard Trump Assets Frozen Nationwide, is not clickbait. It is a description of a legal reality that is already unfolding, piece by piece, and building toward a moment where the most consequential judicial intervention into a former and current president's personal business operations in American history could escalate into a full-scale asset freeze that covers the entire country. Let's start with what has already happened, because the record is clear and it is devastating.
The largest judgment to date has been issued against former President Donald Trump. Judge Engoron has imposed a penalty of more than $350 million against Donald Trump, his adult sons, and his corporation in the civil fraud case brought by New York Attorney General Letitia James. Well, the former president is being ordered to pay more than $354 million in damages. His co-defendants are being ordered to pay another $10 million in fines. The judge has also banned the former president from conducting business in the state of New York over the next 3 years. Eric Trump and Donald Trump Jr. are also prevented from serving as an officer or director of any New York corporation for the next 2 years.
A New York Supreme Court justice ruled that Trump and his companies committed persistent fraud by inflating property values and falsifying financial statements to secure better loan terms and insurance rates. The penalty was more than $450 million in disgorgement and interest, plus a 3-year ban on Trump serving as an officer or director of any New York company, with his sons facing temporary bans as well. But here is what most people missed. The judge did not stop at a fine. He imposed injunctive relief that included a court-appointed monitor to oversee the Trump Organization and restrictions on obtaining loans from New York-regulated financial institutions. That is not a punishment you pay and move on from. That is ongoing judicial control over the day-to-day operations of a major business empire. And then the appellate court weighed in. In a decision that should have made headlines for weeks, the New York Appellate Court upheld the fraud finding. They confirmed that Trump engaged in persistent fraud. They kept the business bans in place. They kept the court-appointed monitor in place. They kept the loan restrictions in place. The only thing they sent back for further proceedings was the exact dollar amount of the penalty. Think about what that means. The fraud finding is now a confirmed legal conclusion of an appellate court reviewing the evidence. It is not the idiosyncratic ruling of a single trial judge. It is the permanent judicial record, The fraud is established, the controls are active, the monitor is inside the organization, and the only thing still being litigated is how many millions exactly Trump will have to pay. Now, let's talk about why the court-appointed monitor is such a consequential piece of this story, because most people do not understand what that role actually does. A monitor in a large civil fraud case is not a passive observer. This is an officer of the court with direct access to the organization's internal financial records. Their job is to review financial transactions, examine records, identify concerning patterns, and report to the court on compliance with the business restrictions and financial prohibitions that have been imposed. The monitor's presence creates an inside accountability mechanism that cannot be ignored, managed through messaging, or dismissed as political opposition. This is someone who sits inside the company, watches how it is being run, and files reports directly to the judge. Why does that matter for the assets frozen nationwide scenario? Because one of the specific things the monitor is watching for is asset shifting. When a defendant faces a judgment of this size, there are financial incentives to move assets into structures that are harder for creditors to reach: family trusts, offshore entities, complex intercompany transfers. The monitor's presence is the specific judicial response to that risk. If the monitor identifies unusual financial transactions or asset movements that appear designed to impair enforcement of the judgment, that evidence goes straight to the judge. And that evidence is exactly what a court would need to issue the emergency asset restraint order that would freeze the empire nationwide. Then you add the loan restrictions. The Trump Organization's ability to obtain loans from New York regulated financial institutions is now constrained by judicial order. For a real estate empire of this size, access to credit is oxygen. You need to refinance maturing debt, access new credit against existing equity, and manage cash flow across a portfolio of properties. The loan restrictions directly constrain that flexibility in the institutional context that matters most for New York-based operations. We have already seen the documented example of Axos Bank refinancing Trump Tower after the major Wall Street banks distanced themselves. Now the judicial loan restrictions are compressing financing options even further. In that compressed environment, combined with the daily accrual growing the judgment obligation and the court monitor watching for asset shifting, the pressure on the organization's financial management is intense. Let's get into the three dimensions that define where this case stands right now: the confirmed fraud finding, the active judicial controls, and the enforcement trajectory that could lead to an emergency asset freeze. The fraud finding. What did the judge actually establish? Persistent fraud carried out over multiple years, involving systematic inflation of property valuations and statements of financial conditions submitted to banks and insurance companies. The purpose was straightforward: to secure more favorable loan terms and insurance rates than accurate valuations would have supported. The persistence, multiple years, multiple properties, multiple financial institutions, is the factual finding that establishes the scheme was deliberate, not inadvertent. This was not an accounting error that happened to favor the defendant. It was a sustained pattern. And when the appellate court affirmed that finding, they did more than agree with the trial judge. They conducted their own review of the evidence and concluded it was legally sufficient to support the fraud conclusion. That means the fraud characterization is now the confirmed legal assessment of the New York Appellate Court, not the idiosyncratic opinion of a single judge. For anyone who thought the fraud finding might be reversed on appeal, that possibility is now gone. The fraud is confirmed, permanently. The active judicial controls. The court-appointed monitor is not a theoretical check on the organization's operations. This is a real person with real authority operating inside the company, reviewing financial records, and reporting to the court. The monitor's presence creates continuous judicial oversight that cannot be simply ignored. The loan restrictions from New York regulated institutions are equally significant. They directly affect the operational flexibility of a large real estate operation that depends on access to credit. Restricting access to the New York regulated financial institutions that are most important to New York commercial real estate is a direct constraint on the business's ability to refinance, develop, or expand its New York-based holdings. And the business bans, the prohibition on Trump serving as an officer or director of any New York company, are the individual-level consequences that flow from the confirmed fraud finding. He cannot run his own company in New York. That is not a fine. That is a structural change imposed by judicial order, the enforcement trajectory, and the asset freeze mechanics. The judgment liens have been filed against specific properties. The daily accrual is running, approximately $87,500 per day, adding to the total obligation. The Attorney General has committed on the record to seize assets if the judgment is not satisfied. And the specific legal tool that the assets frozen nationwide framing points toward is the Emergency Asset Restraint Order. This is a judicial tool available in large civil fraud enforcement cases where there is documented evidence that the judgment debtor is attempting to move assets beyond the reach of the creditor. Courts can issue temporary restraining orders and preliminary injunctions that prevent the judgment debtor from transferring, encumbering, or dissipating assets during the enforcement proceedings. What would it take to trigger that emergency restraint? Evidence. Specifically, evidence that the judgment debtor is taking steps to impair the ability of the judgment creditor to collect through asset transfers, offshore movements, or other dispositions of assets. And the combination of the confirmed fraud finding, the daily accrual, the court monitor reporting on Trump Organization financial activity, and the documented pattern of complex intercompany transactions that the civil fraud case revealed creates the specific factual record that would support an emergency asset restraint application. The monitor is not an external observer making inferences from public information. The monitor is an inside officer of the court with direct access to the organization's internal financial records. If the monitor identifies transactions that look like asset shifting, that evidence goes directly to the judge. And that evidence would form the basis for the emergency application. Let's bring this together with 4 clear points that define exactly where the legal landscape stands. The appellate affirmance of the fraud finding is the single most consequential judicial development in the entire Trump civil accountability story. It establishes the fraud characterization as a confirmed legal conclusion of the New York Appellate Court reviewing the evidence, not the idiosyncratic finding of a single trial judge. It keeps in place the business bans and monitoring that represent the most consequential, ongoing judicial controls, regardless of what happens to the specific dollar amount in further proceedings. The fraud finding is the legal foundation for all of the enforcement mechanisms. The judgment liens, the monitoring, the loan restrictions, the business bans, and the potential emergency asset restraint. If the fraud finding were reversed, the entire enforcement edifice would collapse. The appellate affirmance, confirming the fraud and keeping the controls in place, makes the enforcement edifice permanent in the most fundamental available legal sense. The court-appointed monitor operating inside the Trump Organization is the most consequential ongoing judicial control because it creates a continuous inside accountability presence that produces real-time information about the organization's financial activities. That information would be directly available to support any emergency asset restraint application if the monitoring reveals evidence of attempted asset shifting. Emergency asset restraint orders are most readily available when the creditor can demonstrate to the court that the judgment debtor is taking specific steps to move assets beyond the creditor's reach. The monitor is the specific institutional mechanism that would most directly generate the documented evidence of attempted asset shifting that would support an emergency restraint application. The inside access created by the confirmed fraud findings injunctive relief is the specific enforcement mechanism that makes the emergency asset freeze scenario most legally realistic. The loan restrictions from New York regulated financial institutions are the specific active judicial control that most directly affects Trump's ability to use his real estate empire's credit relationships to manage the judgment obligation. The restriction on obtaining loans from New York regulated institutions, maintained by the appellate affirmance, directly constrains normal financial management flexibility in the specific institutional context that is most important to the Trump Organization's New York-based operations. The documented example of Axos Bank refinancing Trump Tower after the major banks distanced themselves shows how the financing options are already compressing. The judicial loan restrictions add another layer of compression. In that compressed environment, combined with the daily accrual growing the judgment obligation and the court monitor watching for asset shifting, the emergency freeze scenario becomes more plausible as the enforcement proceedings approach their resolution points. Here is what we need to watch as the civil fraud enforcement story continues to develop. The further proceedings on the dollar amount will determine the final penalty target that the enforcement is designed to satisfy. The daily accrual is growing the total obligation every day the case continues. The court monitors ongoing work, reviewing Trump Organization financial transactions, identifying any unusual patterns, reporting to the court on compliance, is the active mechanism that would most directly generate the evidentiary record for an emergency restraint application if asset shifting attempts are identified. The Attorney General's enforcement decisions, including whether to request execution on the lien properties as the appellate process concludes, will determine whether the enforcement moves from lien to physical seizure on the properties that are most immediately within the enforcement reach. And the broader financial scrutiny, the offshore structure questions, the complex intercompany transaction patterns that the civil fraud case's confirmed findings create the documentary starting point for examining, is the background pressure that could accelerate the emergency restraint scenario if any of those structures are found to be moving assets in ways that impair judgment enforcement. So, here is the bottom line. The judge found persistent fraud. The appellate court confirmed that fraud finding. The court-appointed monitor is inside the organization. The loan restrictions are in place. The business bans are active. The judgment liens are filed against specific properties in specific counties. The Attorney General has committed on the record to seize assets if the judgment is not paid. The daily accrual is running, and the specific legal tools for emergency asset restraint available to courts in large civil fraud enforcement proceedings. When evidence of asset shifting exists, are the judicial instrument that the assets frozen nationwide framing is pointing toward as the logical enforcement escalation of a confirmed fraud finding against a defendant whose empire is under active court monitoring and whose financing options are judicially restricted. The judge has already struck hard, the monitoring is already in place, and the enforcement trajectory is moving toward the specific emergency tools that would freeze the empire nationwide if the monitoring reveals the asset-shifting attempts that the confirmed fraud finding makes most likely to be watched for. We are going to be watching every development as the further proceedings unfold, as the monitor files reports, and as the enforcement decisions are made. Drop a comment below and tell me what you think. Does the court monitor ever report the specific asset-shifting evidence that would support an emergency nationwide freeze? Or does the enforcement remain at the lien and accrual stage through the entire appellate process? Hit that subscribe button so you don't miss the next update. I will see you in the next one.